We have breaking news, a massive rebuke from a judge in Florida, slamming President Trump's lawsuit against the IRS as a sham in a backdoor attempt to legitimize the president's $1.776 billion anti-weaponization fund and his immunity from future IRS investigations. MS Now's Fallon Gallagher joins us here on set. James, Peter, Michael are still with us. All right, walk us through this ruling, Fallon.
Yeah, so I want to take a step back first and explain what this case is and why it matters. You'll remember earlier in January, Trump sued the IRS for $10 billion, saying that his tax returns were improperly leaked. This suit raised questions from the beginning because this was Trump basically suing himself as both sides of the federal government. He's a party to both sides. Trump then moved to voluntarily dismiss this suit in May, saying that, not even actually revealing initially that he had reached a settlement, but moved to dismiss it. The judge granted his voluntary dismissal. That's this judge here, Judge Kathleen Williams. Shortly after that dismissal, we learned that there was a settlement agreement. That settlement agreement, of course, gave Trump, his family, immunity from any ongoing IRS inquiries, and it also created the anti-weaponization fund, that $1.776 billion so-called slush fund. After that happened, a group of 35 former federal judges filed a motion with this court, with Judge Kathleen Williams, asking her to revisit it, saying that there seems to have been a sham here. There might have been some collusion, wanting to...
What was the sham?
It's exactly that Trump basically sued himself. So he is both parties of this. And in this ruling today, she's saying that there was never any adverseness here. There was no real lawsuit here. And basically what Judge Williams is saying here today is that this was a complete sham so that Trump could get this outcome with some sort of judicial legitimacy. And I want to read briefly from this because this line just really captures the whole thing. It says, this action was never about a party seeking judicial resolution of a legal issue or a factual dispute. The nature of the suit itself and the conduct of the parties and counsel from its filing make plain that this was an attempt to use the court to provide some legitimacy to an agreement to confer immunity to people and entities affiliated with the president and to earmark billions of dollars from American taxpayers to redress grievances not defined in the law. So really what she's saying, she is ripping them apart, saying that there was never any legitimacy. You conned the court, basically using the court as a vehicle for legitimacy here to reach these ends, and that this should have never been filed in the first place.
Have you ever seen anything like this before?
It is remarkable. And I will say that Judge Williams got briefing from former judges in this case who she actually asked to be amici in the case, friends of the court, to analyze the question that Fallon was just addressing, whether or not this was really a sham. The way I described this from the beginning, the way that she is describing it in this order, which I have not yet read, is simple. What Fallon is describing as a sham, this was an effort to judicially launder a settlement, to give it the sheen of legitimacy via laundering it through the court in a settlement of a case that was never a case.
Here's the part that I'm confused about. Is it the president and his personal team who are accused of the laundering, or is it the United States government who is accused of the laundering?
Really, really interesting question. And the way I would pivot on that question is to say this. If you take the administration's posture in a variety of other contexts seriously, there is no daylight between the two, because what they constantly argue in every context is that the executive branch is unitary, that it is one sole individual. So if you take them at their own word on this, Alicia, that means there's no daylight as between the two.
There's also, though, recommendations here for what should happen to these attorneys.
Yeah, so there's sanctions agreements. One of Trump's attorneys can't actually practice in the Southern District of Florida for the next year. And then there's also possible disciplinary referrals. So she is sending possible disciplinary action that gets sent to the state bars. She notably orders the clerk of this court to send her order to the state bars of both New York and D.C. Why does that matter? Todd Blanche, who has his confirmation hearing to be Attorney General on Wednesday, is barred in the state of New York. Stanley Woodward, who's the Associate Attorney General, barred in the state of D.C. Both of those bar organizations have active ethics complaints for both of those individuals right now.
Michael Feinberg, we normally talk to you as a security analyst. I want you to put on your former attorney hat for me. How could this complicate the confirmation hearing later this week? What legal questions does this bring to mind?
So I don't know that it will complicate the confirmation hearing. What it can complicate is Todd Blanche and Stanley Woodward's future lives. There will probably be some mechanism where they can still practice as Attorney General or Associate Attorney General, even with these Barr inquiries. But this administration, despite how much Trump and his cohort would like, is not going to last forever. And if people like Blanche and Woodward ride roughshod over the rules of ethical behavior, the way that Trump attorneys like John Eastman or Jeff Clark did in the first administration when they tried to overthrow the 2020 election, they're going to find that they're unemployable the minute there's a transition of power. Blanche, Woodward, frankly, a lot of people at DOJ are playing a very dangerous game where they could lose their license to practice law. And once that happens, you don't only lose your ability to be the member of your sort of ersatz political guild and earn a living the way you know how. There's a real reputational cost. You know, if you're a judge and you receive a brief that someone like John Eastman, say, has taken part of, there's enough like storm and stress out there in the media that you know not to take it seriously, because this is somebody who other lawyers decided to not meet the bare minimum ethical bar to practice his profession. And I will say this as a former attorney, that is not a super high bar. Like, if you can't meet it, you know, basically there's ambulance chasers and, you know, who are doing a better job than you. Just do the bare minimum ethically that you're supposed to and you don't get in trouble. But we're in a position where the highest ranking officials at DOJ seem incapable of that.
Colin, it is not very often that I get multiple under-the-breath wows from James Sample. Help me understand just how big of a deal this is.
So we're reading more. This is a 56-page order, so it is quite lengthy. But there is a paragraph that we just came to that could indicate that it is voiding the settlement agreement in its entirety. This says the parties are prohibited from referring to the purported settlement agreement or using, offering, admitting or citing any of its provisions in any judicial, administrative, regulatory, arbitration, or any other official proceeding as evidence of a settlement reached in this matter. Now, there's some questions about that because it's unclear if it's completely avoiding the settlement agreement terms. But to me, at least at this point, from what I've read, this indicates that they can't describe the anti-weaponization fund or the immunity deal as the result of an official settlement reached through a legal proceeding here.
Okay, 56 pages. I'm going to free you up so you can go read it. Come back to us once we have fully processed this. Thank you so much for bringing us reporting and breaking this down for us. Fallon Gallagher, as always.